Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
Fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican for you, sir.
Is that correct?
I didn't ask you to interrupt me. Oh, for Trump's sake.
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. Thank you for joining us. We have the latest filings in the Karen Reed case, and they're spicy. They're spicy. It's everything we wanted to know. Come on, and we're going to read those to you now. Greeners, thank you very much for being first in chat today. The internet is all yours today, my friend. That's what you get for being first. Congratulations. Back at your old tricks again, I see. Good to have you here. Oh, wow. Hope your lunch was break. Lunch break was break. Oh, my goodness. Lunch break was great. There we go. If this is how I'm going to read, it's a bad sign. We'll do better, I promise. Let me turn this music down. Where's the music? It's over there. That's why. Okay. So loud. Chat not on screen. There it is. Found you. Greeners, I saw you. I put you on screen right here. Just briefly. I saw it, but congratulations. Without further ado, let me just tell you what we're going to read, then we're going to jump right over to it. So give me just a minute to get everything lined up. We're going to keep an eye on the Baldwin trial because that's going to be lunch for the next about 40 minutes, 45 minutes.
Shame on you, sir. Someone with more experience.
You guys, shame on me. Shame, shame, shame. All right, where's my viewer? There we go. We're going to go. That's Yannetti. There's Jackson. And here's Karen Reed motion. All right. We're reading the latest motions that just got filed in court. They're dated today.
I saw a chicken fight.
Yeah, I'm going to turn the sound effects down. I love them, guys, but we're going to turn them down for the reading. For those that are curious, here we go. We have documents that were filed by the defense team. This is all wrapped in. Oh, Amber wants to chime in for a minute. This is all wrapped in. Hey, Amber, you're all wrapped in underneath a motion to dismiss. That means the defense is asking for the case to be dismissed, and this is their reason for it. This is spicy. This is coming after the mistrial. Now they're saying, now throw it out. So you know this is good to begin with. Amber, what do you have?
Before you start reading, I need you to check Mod Chat with what I last put in there because nobody has broken this news yet on a live. And you can be the first.
Well, that sounds tempting. Let me check Mod Chat here. Let's see. Trooper. Oh, let's see. Massachusetts State Trooper Michael Proctor has been suspended without pay during duty status hearing today.
There you go. Okay, bye.
Boom. Okay, thanks, Amber. And she's gone, just like that. He's gone. He's suspended without pay. That just came down. That meeting was going on today, where he was originally put on like leave or just moved somewhere else. But that was quick. That is very quick to suspend him without pay. That being said, that's not what this motion is about. This motion, and I'll bring it up on the screen now. Oops, that's not the one. That's also not the one. We're on camera 7, right? There we go. We're on camera. We're going to be on camera 7. Can you guys help see this if I go full screen? Does that work? All right, here we go. This is the Commonwealth of Massachusetts v. Karen Reed. This is the defendant Karen Reed's motion to dismiss. Now comes the defendant, Karen Reed, by and through undersigned counsel, and hereby moves this honorable court pursuant to the 5th, 6th, and 14th Amendments to the United States Constitution and Article 12 of the Massachusetts Declaration of Rights to dismiss counts 1 and 3 currently pending against her on the grounds that the jury reached a unanimous decision to acquit her on those charges, and alternatively, because there was no manifest necessity supporting the declaration of a mistrial with respect to the charges on which the jury had agreed that Mrs. Reed was not guilty, and that therefore a retrial on such counts would violate the double jeopardy protections of both federal and state constitutions. This is big. This is a bold move, too. They must have some details here. The ancient right to a jury trial is no more procedural formality, but a fundamental reservation of power to the American people. By requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretended offenses and arbitrary convictions. More case law here. Prominent among the reasons colonists cited the Declaration of Independence for their break with Great Britain was the fact Parliament and the Crown had deprived them in many cases of the benefits of trial by jury. After securing their independence, the founding generation sought to ensure that whatever happened before would not happen again. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. It follows that a jury acquittal is entitled to the utmost respect of our criminal justice system. The double jeopardy clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. The clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. Perhaps the most fundamental rule in history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed on error or otherwise without putting the defendant twice in jeopardy and thereby violating the Constitution. Here, the very day after a mistrial was declared, undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating jurors, indicating in no uncertain terms that the jury had a firm 12-0 agreement that Mrs. Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the second degree. Given the central importance that the acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Miss Reed on counts 1 and 3 and mandates dismissal of those charges. Alternatively, to the extent the court believes the further factual development is required, the defense respectfully requests that a post-verdict inquiry be held on the issue and the court authorize defense counsel to seek additional proof from the jurors regarding having unanimously acquitted the defendant of 2 of the 3 charges against her, against her prior to indicating to the court they could not reach a verdict on the 3rd charge alone. Background. On June 9th, 2022, Miss Reed was charged with 3 separate indictments with murder in violation of the law, vehicular manslaughter in violation of the law, and leaving the scene of personal injury or death in violation of the law. Funny, all those things were illegal. A jury trial began on April 16th, 2024. On June 25th of 2024, the jury began their deliberations. On July 1st, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. The note was not presented to the counsel for review? She didn't let him read it? Once the jury was seated, the court then read the jury note verbatim in open court. Okay, so that's okay. Without providing an opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. In short, neither defense counsel nor the defendant consented to the mistrial. While the juror's note was read by this honorable court, indicated the impasse was on charges. It did not say whether the charges were those within count 2, i.e. the multiple ways to find guilt, or on count 2 or extend to other counts. The affidavits attached herein indicate the former, not the latter. The court never ascertained from the jury whether its deadlock was in relation to 1, 2, or all of the charges of the indictments. The following day, on July 2nd, 2024, Attorney Jackson was contacted by a juror in this matter. We're going to call him Juror A. Let's see. We don't even know if it's a him or her, but we have a Juror A. I'm going to try the finger puppets on one hand. Ready? Oh, he's green. We can't do green guys. Here we go. Juror A. Juror A contacted him, who stated that she wished to inform him of the true results of the jury deliberations. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder, and Juror A was emphatic that the count 3, I think it should say there, second-degree murder was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. I can't do this. The jury was also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury and death. Another day later, on July 3rd, 2024, Attorney Yannetti was contacted by 2 different individuals, hereafter Informant B and Informant C. So we have Juror A, Informant B, and Informant C, who had received information from 2 distinct jurors, hereafter Juror B and Juror C, both of whom were part of the deliberating jury in this case. David R. Yannetti, affidavit, Informant B, we're going to see that affidavit in just a minute. Informant B sent Attorney Yannetti a screenshot he or she had received from someone, hereafter called Intermediary B, of text messages that Intermediary B had received from Juror B. Oh, so this is a telephone game a little bit. In that screenshot, Juror B texted the following to Intermediary B. It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. Informant C had been in the contact with another individual, Intermediary C, who was a coworker and friend of Juror C. So all of them have intermediaries. And joined a Zoom meeting during which Juror C discussed the trial. Informant C sent Attorney Yannetti below the screenshots of his or her text message with Intermediary C regarding what Juror C revealed in the Zoom meeting. Intermediary C, quote, no consideration for murder 2. Manslaughter started polling at 6 and 6, then ended deadlock at 4 no, 8 yes. Interesting. It was of no consideration for murder 2. Shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip that was all confusing. She should have been acquitted, I agree. Yes, the remaining charges were what they were hung on, and the instruction paper was very confusing. Oh my goodness. The argument is, A, the jury's unanimous conclusion that Mrs. Reed was not guilty on counts 1 and 3 constitutes an acquittal and precludes reprosecution. What constitutes an acquittal is not to be controlled by the form of the action in question. Rather, the court must determine whether the action actually represents the resolution, correct or not, or some or all of the factual elements of the offense charged. The mere presence or absence of check marks on a form is not dispositive. I don't know that word. Here, the attached affidavits by attorneys Jackson and Yannetti reflect statements by 3 deliberating jurors that the jury had reached a final, unanimous conclusion that Miss Reed was not guilty on counts 1 and 3. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the result of the jury's deliberations. Juror A was emphatic that count 1, second-degree murder, was off the table, and that all 12 of the jurors were in agreement she was not guilty of such a crime. David R. Yannetti affidavit has that information. Reflecting text from message Juror B, it was not guilty on second degree. No one thought she hit him on purpose or even thought she hit him on purpose. Reflecting Juror C's statement, relayed by Intermediary C, that there was no consideration for murder 2, and Miss Reed should have been acquitted on that count. To hold that this firm conclusion did not amount to an acquittal simply because it was not recorded in a verdict form would be to elevate form over substance in a manner prohibited by the foregoing United States Supreme Court and Supreme Judicial Court precedents. The Supreme Court's decision in Bluford is not to the contrary. There, a juror had reported during deliberations that the jury was unanimous against the charges of a capital murder and first-degree murder, but split on manslaughter. The court sent the jury back to continue deliberations, and when the jury remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited re-prosecution for capital and first-degree murder. In doing so, the court relied heavily upon the lack of finality of the juror's report. The jury's deliberations had not yet concluded, and when it went back to the jury room to deliberate further, here, by contrast, the juror's statements reflect a final determination that persisted through the end of the deliberations. Even assuming arguendo, contrary to the foregoing, this court finds that retrial would not be prohibited under Bluford. This court can and should afford broader protection under Massachusetts state law. Unlike the United States Constitution, the Massachusetts Declaration of Rights does not include a double jeopardy clause, but our statutory and common law have long embraced the same principles and protections. Part B, re-prosecution is independently barred because there was no manifest necessity to declare a mistrial on counts on which the jury was unanimously agreed. So this is saying the judge made an error. This is okay. So the first part, this first part A, let me tell you what this is. Here they're saying the jury agreed, and just because they didn't fill out the form, it shouldn't matter. The jury agreed that she was not guilty of part of those on murder 2, right? So it doesn't matter if she didn't fill out the form. The second part, they're actually looking at the judge's action, saying there was no manifest necessity, there was no need to declare a mistrial on counts which the jury was unanimously agreed. The judge shouldn't have declared a mistrial. They were agreed. The double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. Thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial. Here, Ms. Reed did not consent to the declaration of a mistrial, rejecting argument that the defendant consented to the declaration of a mistrial because he did not object when the judge ordered the case dismissed. That's see Allan J. Jackson affidavit rejecting the argument because they didn't. He's basically saying, I didn't object at the time, but that shouldn't matter. Usually an objection has to be timely. He's saying it shouldn't matter. We'll get to that in a second. Absent the defendant's consent, state and federal double jeopardy protections bar, as a general rule, retrial of a defendant whose initial trial ends without a conviction. This rule is rooted in the importance of the defendant being able, once and for all, to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably disposed to her fate. Accordingly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. Before a court declares a mistrial for manifest necessity, the counsel must have been given full opportunity to be heard, and the trial judge must have given careful consideration to alternatives to a mistrial. Here, the defense respectively submits that the lack of opportunity to be heard is alone dispositive. Upon receiving a jury note, the court declared a mistrial and excused the jury without consulting counsel. The action was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. Finding no manifest necessity where no opportunity was given counsel, this is a case law, they found no manifest necessity where no opportunity was given counsel to argue the propriety of the question or the necessity of the mistrial. So they're saying case law says that if you don't ask the two sides if they're cool with it going forward, then there's no manifest necessity to, if the two sides aren't cool with the mistrial, there's no need to go that way. Because remember, they could keep sending them back. You could say you need to deliberate further. Let's see, finding no manifest necessity where the trial judge first ruled that he was going to declare a mistrial and then, almost as an afterthought, unenthusiastically asked whether the counsel objected. The record is independently lacking on the second prong, as it reflects no careful consideration of alternatives to a mistrial. Here, there was one obvious alternative, to simply ask the jury to specify the charges on which it was deadlocked. Had the court done so, and the jury articulated its verdict consistent with the statements of jurors A, B, and C, the double jeopardy implications would have been clear and decisive. Indeed, with virtual unanimity, the cases have applied collateral estoppel to bar the government from relitigating a question of fact that was determined in defendant's favor by a partial verdict. When the jury hands down a partial verdict, a final judgment is rendered on the counts upon which the jury has reached agreement. The Supreme Judicial Court's holding, that courts should not request partial verdicts on lesser included offenses charged in a single count does not pertain here. As the Roth Court acknowledged, inquiry concerning partial verdicts on lesser included offenses that have not been separately charged carries a significant potential for coercion. Declining to require a court to consider giving a jury new options for a verdict in the form of a partial verdicts on lesser. This is some crazy writing here. Declining to require a court to consider giving the jury new options for a verdict in the form of partial verdicts on lesser included offenses, where under Arkansas law the jury options were limited to either convict. Why is there two twos right there? We're limited to two. The options were limited to two. Okay. Either convict on one of the offenses or acquit on all. Such inquiry, in effect, implies that the jury should consider conviction on the lesser count. No similar danger is present here, as here the jury was asked to return 3 separate verdicts on 3 separate counts. Distinguishing situation. Where a defendant has been charged in separate indictments or complaints, each with a separate verdict slip. In this circumstance, where the jury reports a deadlock without specifying the counts on which it has reached an impasse, it is straightforward, and the defense contends, constitutionally required to follow up as to ask whether the deadlock relates to some as opposed to all counts. Indeed, we saw this in Tennessee with just recently. The cold case trial. Indeed, the Supreme Judicial Court has explicitly stated where a complaint or indictment in multiple counts charges multiple crimes, a general verdict could be returned as to one of the counts despite deadlock on the other counts. I think case law is strongly on their side. Alternatively, the defense is at least entitled to conduct post-verdict inquiry. Undersigned counsel did not initiate the communication with jurors A, B, and C, which resulted in the disclosure of information that is memorialized in counsel's affidavits that are appended to this motion. Should this court find that further factual development is required, the defense respectfully requests that the court conduct a voir dire of the jury and or evidentiary hearing to substantiate the existence of an acquittal. Should the court seek the affidavit of each juror, jurors A, B, and C, the defendant asks for the court to authorize undersigned counsel to initiate contact for the sole purpose of asking each juror whether the jury had unanimously agreed that the defendant was not guilty on counts 1 and 3. The footnote back here says Massachusetts law, to the contrary, clearly permitted the jury to return a partial verdict on some but not all counts. So he's asking for the third step, because the first is that the jury agreed to acquit on those charges, and there should have been an acquittal, at least partial. The second was that the judge screwed up and declared a mistrial before the counsel was consulted. There was no manifest destiny for the mistrial, or manifest need for the mistrial, and thus there was a judge error on that part, and it should be thrown just based on that count. And this third arm of this is that the defense, if those don't reach the level of mistrial or of getting dismissed, then we want to sit down with the jurors and ask them, all of them, and say, hey, did you guys actually all agree on these things? The Supreme Judicial Court has held that because of the importance of the issue, juror bias is a legitimate subject for post-verdict inquiry. It is similarly a fundamental tenet of our system of justice. The defendant may not be retried for a crime on which she was previously acquitted by a jury, and the defense submits that post-verdict inquiry is equally warranted in the present context. Just as in the court in McCallop approved questions as to the existence of racial bias, questions about a matter more attenuated from the content of deliberations, whether the jury had unanimously concluded that Miss Reed was not guilty of counts 1 and 3, do not invade the heartland of the jury deliberations, but preserve the defendant's precious rights to the favorable outcome of a jury trial and to the protections of the double jeopardy clause and its related state judicial protections. Conclusion: For the foregoing reasons, Miss Reed respectfully requests that this honorable court issue an order dismissing counts 1 and 3. Signed by Mr. Yannetti. Now, they've referenced 2 other documents. We've got the first one by AJ right here. Affidavit of Allan Jackson in support of the defendant's motion to dismiss. I, Allan Jackson, declare I'm a partner of the Los Angeles law firm of Worksman, Jackson, and Quinn, LLP. I have been licensed to practice law since 1994. I'm counsel for Karen Reed, on the docket number, appearing on her behalf in Commonwealth of Massachusetts, pro hoc vice. On Tuesday, July 2nd, 2024, I was contacted by Juror A, a true name and identity withheld to maintain anonymity, based on my conversation with Juror A, and that juror's description of who he or she is, where he or she was seated, and certain identifying information, name and occupation, disclosed during the voir dire process, I was able to positively identify which juror he or she was. So he says, I can vouch this was an actual juror. Juror A told me that he or she was seeing inaccurate reports about the split among the jurors related to the mistrial that the court declared the day before. Juror A stated that he or she wished to be respectful of the privacy of the deliberative process, but did wish to inform me of the true results of such process. Juror A indicated, hang on here. Let's go continuous scroll down, make it a little better. Juror A indicated that he or she believes it important to disclose such results because he or she believes that those results significantly impact Miss Reed's rights. Juror A told me that the result of the deliberations was that the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder. Juror A was emphatic that count 1, second-degree murder, was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. Juror A told me that shortly following the determination regarding count 1, the jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury death. On July 1st, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. Once the jury was seated, the court then read the note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. Neither Miss Reed nor her counsel consented to the entry of a mistrial. Defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked, including lesser included offenses, and on which count the jury may have arrived at a verdict. Nor did the court, on its own, inquire if the jury foreperson on which counts the jury was at an impasse and whether the jury could or did reach unanimous agreement on any of the other counts. Had the court so inquired, it appears clear that not guilty verdicts would have been recorded for count 1 and 3. Miss Reed was denied her right to receive those verdicts in her favor. The foregoing is true and correct to the best of my knowledge and belief under penalty of perjury under the laws of the United States of the state of California and the United States of California. The United States and the state of California and the Commonwealth of Massachusetts executed this day on July 3rd in Los Angeles, California. Signed by Allan Jackson. There's Allan Jackson's, and now we have another similar affidavit from David Yannetti. Somebody could teach me how to keep that setting always turned on. Affidavit for David Yannetti, support of the defendant's motion to dismiss. I, David R. Yannetti, do hereby depose and state that the following is true to the best of my knowledge and belief. I'm an attorney licensed in Massachusetts since December 20th, 1989. My main office address is 44 School Street in Boston, MA, Suite 1000A. On January 29th, 2022, I was retained to represent the defendant, Karen Reed, regarding the above captioned matter. On July 3rd, I received communications from 2 different individuals, hereinafter Informant B and Informant C, who had received information from 2 distinct jurors, hereinafter Juror B and Juror C, both of whom were part of the deliberating jury in this case. To my knowledge, Informant B and Informant C do not know each other. On July 3rd, 2024, Informant B sent me a screenshot he or she had received from someone, hereinafter Intermediary B, of text messages that Intermediary B had received from Juror B. In that screenshot, Juror B texted the following to Intermediary B. It was not guilty on second degree and split in half for the second charge. When the judge sent us back with that Hernandez thing to look at the other side, it turned into a bowling match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. They gave us free counseling forms when we left. Based on the first name of Juror B given to me by Informant B, I believe that I am able to positively identify which juror he or she was and confirm that he or she was a deliberating juror. On July 3rd, 2024, Informant C contacted me to say that he or she personally knows Juror C as they used to work together. Informant C and Juror C also have a mutual friend, hereinafter Intermediary C, who is current coworker and friend of Juror C. Informant C told me that he or she had posted something about the Karen Reed case on Facebook on Monday, July 1st. He or she told me that he or she believes that the post led Intermediary C to text him or her and inform him or her that Juror C was a deliberating juror on the case. So she posts something, or I'm just going to say she. She posts something. Her friend reads it and says, hey, did you know that so-and-so was actually a juror? Informant C told me that she thereafter reached out directly to Juror C via text message and discussed his or her experience as a juror in very general terms. They discussed what an exhausting experience it was and that Juror C was relieved that it was finally over. Intermediary C told Informant C that Juror C would be participating in a Zoom meeting with a number of friends to discuss what happened with the trial. Today, Informant C sent me 3 screenshots of text message exchange he or she had with Intermediary C. Informant C told me that Intermediary C was reporting to him or her during this exchange what Juror C had revealed during the Zoom meeting. The text message exchange reads as follows. Quote, no consideration for murder 2. Manslaughter started polling at 6-6, then ended deadlock at 4-no, 8 yes. Quote, he or she was very consistent in the fact that they could only consider things that were admitted into evidence. Ultimately, he or she voted no because the cause of death was twofold of hypothermia and head injury, of which he or she was convinced that the vehicle did not cause both. Quote, the whole jury felt very intimidated by Higgins' presence at the end. He was invited there by John's brother. Quote, she's not what she's going to do. This is tough. I'm just going to read the first one. He's not sure what he's going to do. He's going to lay low for a couple days and see where it takes him. Hasn't ruled out anything. I'm just assigning a gender. We don't know. The jurors have all have a group text going. Interesting. It was no consideration for murder 2. Shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip that was all confusing. She should have been acquitted, I agree. Yes, the remaining charges were that they were hung on, and that instruction paper was very confusing. What a great experience for him. Amazing that they let the Alberts in the last day. I think it's the Alberts. That was a spelling. She felt very honored to be part of it. She was a redacted physical description of Juror C. Everybody else was from a professional walk of life. They all got along and never heated. They agreed to disagree and respected each other. That's the way it should be. I knew it was an intelligent jury. They will be studying this case in law programs for years to come. How not to investigate and try a case. How not to investigate and try a case. That's funny. If they agreed on no for murder 2, they should make that clear to the DA and the court. It's basically a case of double jeopardy if she's retried on that charge. Based on the description of Juror C given to me by Informant C and confirmed by the redacted content of the text message exchange, I am able to positively identify which juror he or she was and confirm that he or she was a deliberating juror, signed under the pains and penalties of perjury. I like that. Look at the alliteration. Pains and penalties of perjury. This day, 6th day of July, 2024, signed by David Yannetti. All right. What that means, this could be huge. Oh my goodness. Are they coming back already? Do we already miss our lunch break? No, we didn't. Okay. We're fine. We're fine over here. They're still at break. What this means is that the state wants to say, at least on those 2 charges, get them thrown out, get them dismissed, so she can't be charged again, because they think it is double jeopardy to try Karen Reed on those same 2 charges again, where a jury, a verdict of her peers, was able to unanimously, 12-0, agree that she was not guilty of that. If what they have said in this affidavit and if this motion checks out, which I think the judge at a bare minimum has a duty to do, is to do a post-verdict analysis and reach out to the jurors. And it's a pain in the butt, but this is an extraordinary case, I think. And if it checks out, I think that they have to dismiss those 2. That's my take on those. That she still would face the second charge, the manslaughter, right? But wow. Okay, I've missed a whole bunch of what happened in chat. A quick breakdown. Karen Reed's legal team is asking for 2 of the 3 charges to be thrown out in her case. Murder 2 and leaving the scene of an injury and a dead body type thing, hit and run. That's pretty much what it was. Those 2 charges, the jury unanimously agreed that they were not proven, and that they would have voted to acquit on those 2. They were only hung on one of the charges, and they were hung in favor of convicting on 8-4, convicting for manslaughter. So they're saying that, hey, if this goes forward again, Karen Reed would only face 1 charge of manslaughter. She wouldn't face all the other charges as well. So that would be a huge difference. That is spicy. The fact that 3 jurors reached out and are out and talking to people about this is just, wow. Whoa, mind blown. That is a huge document. On the same day that Trooper Proctor gets put, his pay is cut. It's gone. He is not getting paid anymore to work for the state as a result of the inquiry. That is crazy. That is absolutely crazy. What are your thoughts on this? I can't do finger puppets and all those. If I had read it before and I knew what was coming, it'd be easier, but I've got the scroll wheel and stuff is giving me problems. When you see sick, spelling isn't changed. I think that's what SIC means. Spelling isn't changed, but it should be. It means there's an error. So the judge, according to the defense, declared a mistrial in error, because she didn't consult the counsel to see if they agreed with what they needed to do. The jury reached a verdict, and that verdict was unanimous. So those 2 counts should be thrown out, or at a minimum, there needs to be a post-trial inquiry where the defense is requesting the right to ask just that one question: were there charges that you guys all agreed on? If they all come back, and it's basically poll the jury, which didn't happen because it was a mistrial. But what did the note say? Apparently the note was read verbatim. Lenova, this is crazy. Do you see Bev saying yes to this? No, not on the first or the second, but on part 3. I see her saying, okay, this is new information, but honestly, is it new? Because I would love for them to come in and bring the jurors in and ask them these questions and have the jury to say, Judge, we told you this afterwards when you came in to say, hey, I want to talk to you before you leave. I'll meet you in the juror room. I would love to know what happened in that conversation. Was the judge aware of this after the mistrial and just did nothing? Proctor has been rehomed. Goes back to that same verdict form, which had problems. The verdict form had major issues. And it was brought up, it was objected to at the time. Let's see. Okay. I've got to set things up here. Okay, Kurt mentioned if it's not on the form, it doesn't count, and the judge will deny the motion. I'm confused. That's why I don't think he's going to rule. The judge would support the fact that they did have a unanimous decision, because they didn't turn in a unanimous decision to the court. And that's their job. They should have done it. The form was confusing. They should have asked the question. I think that's what the judge will say. The second one, that seems more like an appellate issue, but you can't really appeal mistrials. So I don't know where that one stands. I don't think that'll move at all. And the third one, I think, is where they have the most ground. Amber, what's up?
Hey, I just kind of want to help set the record straight and make sure that we're clear. Everybody's saying that they didn't poll the jury because it was a hung jury. The issue isn't about polling the jury. The issue comes in with the last jury note coming in. The judge only told counsel that the jury was at an impasse.
Yeah.
They were not allowed to see the notes that the jury sent the judge prior to her declaring the mistrial. She read it aloud verbatim as she declared the mistrial.
So this presents an interesting problem, though, because what's the proper venue for getting that resolved? You can't like reopen the case, back up, call the jury back. They clearly can't deliberate any further. It's not a conviction, so it's where you would, if it was a conviction, this would go, that should be headline of the appeal.
Right.
What happens next?
So
I think the only thing that can happen potentially is on the next trial, if the Commonwealth, cops going by, if the Commonwealth does decide to pursue a second trial, that this can be brought up and the judge can exclude them because of that, because of this reason, because of this information.
I think you're putting the cart before the horse.
Okay, go ahead.
This can absolutely be remedied prior to the next trial. We can actually do a jury investigation. What case was it that Maya's case did it, but what criminal case was it? I think we've done one with a criminal case too.
I don't remember.
So on good faith basis, this is the attorneys putting in an affidavit saying, upon, what's the phrase, upon what?
Basis and belief, information and belief, yeah.
So they're saying that this is true to the best of their knowledge, and this is something that cannot be ignored, in my opinion. I am not a legal expert, so I'm not going to say definitively that this is a judge error and it needs to be corrected before next. I don't have that expertise, but in my opinion, if she ends up denying this motion and not doing anything about the counts 1 and 3, then I think it needs to be escalated up on an emergency basis, because this can be rectified now by doing pulling the jury back and doing individual voir dire of each jury member.
Yeah,
but I'm not a legal expert.
I know a couple of legal experts are going to be checking in. Amber, thanks once again for your call. This is ATS on the phone. This is Amber. Clipson's Vixen in chat, one of our great mods, and also the source of this information. So thank you for that. All right,
no problem. It'll be interesting what they do from here. I don't see this not being intervened if Bev just dismisses the motion. So we'll see.
We'll see. Amber, we're going to have to wrap this up because we're going to go back to Alec Baldwin's very heated motion debate preceding his jury trial that starts Wednesday. It starts in just a couple of minutes here. We've followed it this morning already. We've got a portal set up, so I'm going to re-portal us back over to that one. Amber, thanks for the documents on this. Thanks for the heads up. Appreciate you.
Not a problem.
We'll see you.
Have a good day, guys.
Bye. All right, what we're going to do is wrap this up. I know there are a lot of people that are going to be talking about this probably later tonight on this evening, and a few probably earlier, as this is making its waves through the legal world as we're looking at this. This is crazy to hear that a jury reached a verdict of not guilty on 2 charges, but ended up being hung, and now that the defendant could be charged again. try it again for the same charge. Double jeopardy should apply, I think, in this case. But all right, we're going to portal back over to New Mexico, where we're watching the Alec Baldwin trial. It hasn't started yet. It looks like this hasn't started, but we want to get there before it gets back, so we don't miss a moment of it. We have to keep the timeline straight, so we're going to do a portal and a new live stream. Tonight, when you go home, please hug the people you love, smile at someone to make their day just a little bit better, and please stay safe till we go live again in moments in New Mexico. We'll see you over on the other side. Bye-bye.